Thank you. Ladies and gentlemen, welcome to the home of the Suffolk County Bar Association. We are honored to play host to the Suffolk County Criminal Bar Association and this very important event tonight. Before I introduce who I'm here to introduce, I'd like to have a few acknowledgments. First, you'll find, you probably saw coming in today, the staff of the Suffolk County Bar Association worked very hard to make this room presentable for us tonight and appropriate for us tonight. So I'd like to start by thanking them. First, a young man who's one of the rising stars of the staff of the Suffolk County Bar Association, Mr. Joseph DiBenedetto. Joseph, thank you. Second, a former president of this association and someone who has worked tirelessly and endlessly for its betterment and to see it continue and to continue to thrive, and that is Barry Smolowitz. Barry, thank you so much. Barry's our director of technology, so if things go right tonight, he takes all the credit. If it goes wrong, you can blame me. All right? Third, you saw probably she is the executive director of the Academy of Law, and that's Cynthia Dorler. Cynthia, are you here? There she is. Stand up. Be acknowledged. If you've taken a continuing legal education class from the Academy, you know Cynthia, and she does a fabulous job and has done a fabulous job. And finally, the person who is not only the face, but I would probably argue the heartbeat of the legal community for the past 40 years in Suffolk County. This is the House of Lakova, Jane Lakova. Jane, our executive director. Thank you, Jane. All right, now what I'm really here for, and that is to introduce to you the president of the Suffolk County Criminal Bar Association, Danielle Korsh. Danielle.
Thank you, Mr. Messina. On behalf of the Suffolk County Criminal Bar Association, I would like to thank the Suffolk County Bar Association Executive Director Jane Lakova, as well as Suffolk County Bar Association President Dan Tambasco and President-elect Vincent Messina for allowing us to use this great hall tonight. To all of our members that are here tonight, I encourage you all to join the Suffolk County Bar Association if you are not already a member. Tonight, I would like to welcome you to the Suffolk County Criminal Bar Association's second candidate debate for the office of the Suffolk County District Attorney. My name is Danielle Korsh, and I am the president of the Suffolk County Criminal Bar Association. Since our inception in 1965, it has been our privilege to host a debate amongst the candidates for the office of Suffolk County District Attorney. This debate is a long-standing tradition within our association and provides a platform for the free exchange of legal ideas. Tonight, I am pleased to welcome with us the current Suffolk County District Attorney, Tim Sini. I also welcome to the stage his challenger, Ray Tierney. I want to thank both parties for agreeing to participate in this event. It is an evening long celebrated by our membership. While the Suffolk County Bar Association generously opened their doors to all of us, this is a criminal bar event, and our association alone is responsible for the rules and the conduct tonight. Before we move forward to discuss the rules of the debate, it is important to make clear that the Suffolk County Criminal Bar Association does not endorse nor favor any candidate for the office of Suffolk County District Attorney. Our role as host is, and always has been, to provide both candidates a fair and neutral platform for debate. The rules of the debate are as follows. Each candidate will be allowed a brief opening remark, no longer than 3 minutes. There will be a total of 10 questions posed to each candidate during the debate. Each candidate will be allotted 2 minutes to answer the question. The opposing candidate will be afforded 2 minutes to respond. Lastly, there will be 1 minute for rebuttal. I am going to moderate the debate. The first question posed to each candidate will be one submitted by their adversary. This question was not disclosed to either party in advance. The remaining 9 questions were chosen by me from those submitted by our members, and they are under seal. At the conclusion of the debate, each candidate will be allowed a brief closing remark, no more than 3 minutes. Jason Bassett, our second vice president, will be keeping track of time. Now, unless anyone has any questions, we will begin. Earlier, the parties flipped a coin to determine who would begin. The winner of the coin toss decided whether they wanted to present their opening statement first or second. District Attorney Sini won the coin toss and chose to open first. Accordingly, I now invite District Attorney Sini to begin with his opening remark.
That was the first coin toss I ever won in my life, I think. I want to thank the Suffolk County Criminal Bar Association for organizing this event. And I want to thank the Suffolk County Bar Association for hosting us here this evening. And I want to thank everyone for being here. We're proud of the work we've been doing in the Suffolk County District Attorney's Office. We've reformed the office and made it stronger each and every day. We've reduced crime each and every year. The assistants and the investigators and the paralegals and the support staff and everyone in the office is working tirelessly to achieve justice and to keep Suffolk County safe. We've accomplished a lot. We've become leaders on many issues, statewide and even nationally. And we've done this despite significant challenges. I mean, take a step back for a moment and think about this and put this in perspective. You had a change in administration, which would be difficult for any office in any normal time. You had the most sweeping change of criminal procedure law in a generation. And then you had a global pandemic. Despite those challenges, we've reformed the office, reduced crime each and every year, and have brought some of the most significant cases on a variety of criminal justice fronts, public safety fronts, not only in the state, but in the region. And we're being recognized statewide and nationally as a leader. Whether it's the work we're doing on the drug epidemic, whether it's the work we're doing on gang violence, human trafficking, environmental crime, corruption, criminal justice reforms like our Conviction Integrity Bureau. We've reformed this office, made it stronger than ever before, reduced crime each and every year, and have become a leader in this state. And we're going to continue to do just that. Thank you.
Thank you, District Attorney Sini. Mr. Tierney, you now may present your opening remarks.
Thank you. And thank you to the bar, and thank you all for coming. For those of you who don't know me, I'm Ray Tierney. I'm running for Suffolk County District Attorney under the Republican and Conservative lines. I'm running to bring integrity, ethics, experience, and independence to an office that desperately needs it. I am not a politician. I have never run for office before. I'm not even a member of either of the two parties that have given me their endorsement. But I've gotten this opportunity, and I've been given this endorsement because of my record as a prosecutor. And when I talk about that, I'm talking about 27 years as a prosecutor. I began my career in the Suffolk County District Attorney's Office, where I spent 13 and a half years. From there, I went to the Eastern District of New York, and I was a federal prosecutor on Long Island, and I prosecuted cases there for 11 and a half years. After that, I went to the Kings County District Attorney's Office as an executive assistant district attorney, where I ran their body-worn camera unit, their crime strategies unit, and their violent crime and gangs unit. And this is important because for the first time in forever, you are going to have a district attorney who prosecuted and participated in many of the most important and consequential cases in Long Island over the last 10 years. When I talk about consequential cases, I'm talking about all of the MS-13 cases that everyone's read about, all of those murders, all of those cases that he's taking credit for, I did. Massive Colombian cartel cases, okay, where we brought bosses, cartel bosses, we prosecuted them, gave them 40 years in jail. Political corruption cases, corrupt Republicans, conservatives, and Democrats, I held them to account. I made them give back the money they stole from the citizens. White-collar crime cases, child exploitation cases, computer crime cases, crimes against women. I brought the abusers into court, and if they wouldn't take responsibility for what they did, I tried them when it was appropriate, and I held them to account. And this is important. This is important because we see what is happening with disastrous criminal justice reform and an ineffective an ineffective district attorney. We need a district attorney with experience. We need a district attorney who understands that the case doesn't end at a splashy press conference. I will do what I've done my entire career. I will follow through. I will hold those who seek to damage the citizens of this county to account, and I will prosecute those, and I will make justice available for everyone.
Thank you, Mr. Tierney. The rules of our debate were provided to each candidate in advance of tonight's event. Our association is bound by those rules. With that in mind, the first question asked of each candidate this evening was one submitted by their adversary. Our association requested that each candidate submit 3 questions in order of preference. I reviewed these questions to verify that they were not the same or similar to those submitted by our members. Of those 3 questions, I then chose one that covered a topic not addressed tonight. I will read this question verbatim, exactly as it was submitted. Debate question number 1 tonight goes to Mr. Tierney. Mr. Tierney, District Attorney Sini poses the following question to you. You claim to be an independent candidate, but you were handpicked by the party bosses of Suffolk County to run for this position so they can regain a stronghold on the DA's office like they had under the Spoda administration, which you were a part of. Please explain how you got your political appointment at the Suffolk Casino, a job controlled by the party bosses, and a classic political patronage mill, and why more than 1/3 of all of your campaign funding has come directly from the Suffolk County party bosses. How can you say you are independent when you are accepting hundreds of thousands of dollars from party leaders to fund your campaign and lining your own pockets with a job handed out to you by political party bosses?
Well, that's an interesting question because the conservatives gave Tim the nod last year, and I guess he doesn't like it because he didn't get it this year. That's politics, and it's not unfair when it doesn't go your way. But be that as it may, I've been a prosecutor for 27 years. I've got 4 children. I've got my mother-in-law's working at home. I had to leave the Brooklyn DA's office, and I had to get a job. So that necessitated me leaving my job and coming to Suffolk County because you can't run and work full-time and then run from a county other than Suffolk. So the job options were limited. I tried to get a job with the county executive's office, but Steve Malone wouldn't have me. So I managed to get a job, and I do what I'm competent to do. I interpret federal law, anti-money laundering statutes, Bank Secrecy Act statutes, like I've done my entire career. I write protocols and I work hard. Okay, I'm eminently competent for that job. It's not as though I was 34 years old and became police commissioner without ever becoming a cop. All right, that's a job that you get handed. And with regard to my money, he outspends me 5-1, and my donors feel more comfortable giving the party money because they're afraid of repercussions from him. Oh, and by the way, he was Spoda's boss for 16 months and Burke's boss for 16 months and did nothing, hid under his desk and said nothing and waited for my colleagues in the Eastern District to clean up his mess.
So, right, I mean, this notion that I was Spoda's boss, and perhaps that may work on the campaign trail with certain people because they just don't know anything about the criminal justice system, but in this room, there's no one in here that believes that. And the fact of the matter is, we have taken the office out of politics. And the evidence of that is the fact that all the party bosses are supporting you. And it was very clear to me why the Conservative Party did not endorse me this time around. They literally told me during the screening, because we don't play politics. We don't hire the people they want us, we don't hire the people they want us to hire, and we don't play politics. We are fiercely independent and proud of it. We took the office out of politics, created a professional public integrity bureau that follows the evidence. We're proud of the cases that we've brought, charging elected officials on both sides of the aisle, charging labor leaders, business owners, police officers. We're equally proud of the cases we haven't brought where the evidence doesn't justify it. You are basically their hope, the leaders' hope, that they can once again have control or at least influence over the DA's office. And our team is just not going to let that happen. We need to have a politically independent office. That's exactly what you have today, and that's what you're going to have after November 2nd.
So let's talk about that labor case that you took. Under Spoda, there was an investigation under Local 355, which is run by Kevin Barry, your chief investigator's brother. When John Barry came in, he thwarted that investigation. He shut it down, just like the old days. He then said, let's go after their rivals, and they went after the Plumbers Union, which was their rivals. The case continued unbeknownst to the Southern District. They took up the case. On October 1st, the indictment came down. On October 13th, Kevin Barry wrote an op-ed in the New York Post thanking the Southern District for prosecuting that case because it directly benefited him and his membership. That is unethical. And in fact, it's my understanding that the Southern District is going to have to do an ethical violation and do a disclosure about John Barry, your chief investigator's conduct. And so my question to you, did such a disclosure occur?
So this is what you've been doing, okay?
Sorry, time for that question has ended. We'll move on to the second question now.
Yes or no? Did the disclosure occur?
Gentlemen, the rules were explained at the get-go, please.
We're going to move on to the second debate, the first debate question. And this debate question goes to Mr. District Attorney from Mr. Tierney. When you had the chance to fire James Burke while you were the Assistant County Executive for Public Safety, why didn't you? Why did you allow him to resign?
So the only person on this podium who has a connection to Spoda and Burke is Mr. Tierney. In fact, I was in the room when the county executive forced Burke to resign. And this idea that I was Spoda's boss or had some sort of oversight, control over the police department is just one of the many lies that he's trafficking in the community. At the end of the day, the department experienced a major scandal. The county executive removed Burke, asked that I go to the department to set the ship straight. I did just that. We restored integrity to the leadership of the department, and we moved it forward. And we implemented a number of different initiatives. But it became clear to us that if we truly wanted to reform the criminal justice system, we had to reform the district attorney's office. And that's why I ran. And in fact, it wasn't shortly thereafter that Mr. Tierney came to me and asked for a job in the administration. If he was so concerned about how we handled the police department, why is he asking me for a job? And so what we did was we got to work, and we reformed the office. We brought in tremendous talent, and we kept tremendous talent, and we invested in our people. We overhauled our training program, we invested in technology, and we brought some of the most significant cases in the office's history. And all the while, despite all the challenges that we've experienced with the pandemic and the change of discovery and bail laws, we've been able to keep Suffolk County safe. So while we were reducing crime in Suffolk County to historic levels, while Mr. Tierney was the crime strategist in Brooklyn, crime was literally going through the roof, and his team's response was to dismiss 40% of felonies. We don't want those city protocols, those policies here in Suffolk County.
It's interesting that that he'll talk about, the district attorney will talk about my time in Brooklyn, because if U.S. News and World's report came out with the safest cities in America, Nassau County was number 1. Brooklyn, with all of our challenges, came in at number 18. Suffolk didn't make the list. And with regard to my relationship with SPOTA, the problem is you're in the wrong room. All of these people are my colleagues. They knew what I went through with Tom SPOTA, how I was almost fired for insubordination, and how I was one of the few district attorneys, few individuals in Suffolk County who actually stood up to what was going on and paid the price for it. Unlike you, I wasn't higher on the hierarchy than him. I was lower, and I bore the consequences for that. But I managed to get out and go to the Eastern District of New York. As far as asking you for a job, do you have a copy of my resume? Do you have a cover letter? I never asked you for a job. You asked me for advice, which you didn't follow.
Right, we didn't meet in the California diner. You didn't say you wanted to come and join the administration?
Gentlemen, please.
No.
We didn't meet at the California diner and you didn't ask to join the administration?
Mr. Sini, you're going to get a minute rebuttal after.
Okay.
I'm going to add this time back to Mr. Tierney.
That flat out didn't happen. He asked me my advice. I gave him his advice. He didn't follow it because he has zero experience as a prosecutor. And despite having zero experience as a police commissioner, his quid pro quo for keeping quiet and being part of the cabal was becoming police commissioner, despite the fact that he had zero experience as a police commissioner. He's the independent one. The independent one became police commissioner at 34 years of age with absolutely no police background at all. He's never even been in the room with a criminal before. That's ridiculous.
This, again, you're going around town trafficking in these lies, and in many instances you're doing it on the back of the victims, which is disgusting, and we're going to get to that in a moment. But let's just go over my experience, because I think you're confused as to what job you're applying for, okay? Put aside the fact that I tried felony federal cases, including murder trials. Put that aside. I ran...
Name of the case.
I tried a hitman case, I tried U.S. v. Cleve Barnes, I tried U.S. v. There's several murder trials and several more drug trafficking trials, but put that aside. You're not running to be a trial assistant. You're running to be the CEO of one of the largest prosecutor's office in the country, and you have zero management experience. Despite your decades of serving as a prosecutor, you've never actually been a manager. Conversely, I've run the 11th largest police department in the country successfully, and I've run the DA's office for the past almost 4 years successfully. And we're going to continue to move the office in the right direction, and we're doing it in a way now that is really tapping into the folks throughout the office, bottom-up change, and we're going to be stronger than ever.
Thank you. We are now going to move on to debate question number 2. Mr. District Attorney, your debate question number 2 reads, the District Attorneys Association of the State of New York strongly opposes existing discovery reform and has sought permission to file amicus briefs in cases involving discovery reform. That organization has recently elected you as its next president. What is your position about the current state of the discovery statute?
It needs to be changed. It doesn't adequately protect victims and witnesses, and we need to ensure that we have laws on the books that protect our witnesses and our victims so that we can build criminal prosecutions and keep Suffolk safe. And as DASI's next president, I will work with all of the elected DAs throughout the state. I will work with all the stakeholders in the criminal justice system, and we will work to change some of those discovery laws. We'll also work to change the bail laws. You know, we've been opposing the bail laws from the get. This is another lie my opponent is trafficking in the community. We worked very hard to oppose the bail laws, and we had some successes, of course, in not only in January, but also then in April of 2020. But there needs to be further changes. And I'm going to work with my colleagues throughout the state, and I'm going to work with the stakeholders to strengthen our laws to keep our communities safe.
Mr. Tierney, would you like a chance to respond?
Yes. You know, it must be 3 weeks before the election because suddenly my opponent is not in favor of bail reform. It goes well before bail reform. He's been in office for 3.5 years. He is the party of radical criminal justice reform, and he has not stood up against it. He has not been a loud enough voice against these bail reform and criminal justice reform acts. And you're talking about bail reform. So let's talk about the less is more statute. It's a disaster. I've been saying it. You should say it. The work release reform, disaster. The clean slate law. Okay, so what the clean slate law means is you're going to have absolute expungement of criminal records between 3 and 7 years after somebody gets convicted. Not so they could get a job, but we're talking about DNA, fingerprints, so you can't keep the community safe. If a recidivist commits a crime, leaves DNA at a murder scene, you can't find it. Okay, you haven't said enough. The border is a disaster. We need more. We need, not only do we need someone to advocate against criminal justice reform, but we need an effective prosecutor, okay, because that fentanyl is streaming across the border. It's being mixed in with cocaine. Okay, we need a prosecutor who's going to prosecute those individuals responsible for the overdoses in this case. Like you said, Justin Smith was responsible for those overdoses. You didn't do anything about it. You didn't indict him. He got out of jail, and 6 people are dead. And then you had a press conference. You congratulated for keeping him in. You said how important it was to keep him in. Where's Justin Smith now? Justin Smith is out. So when you said you had a strong case, when you said he was responsible, were you lying then or are you lying now?
Mr. Sini, would you like?
We worked with the DAs throughout this state to oppose the bail reform. I wrote an op-ed opposing the bail reform. I appeared on television opposing the bail reform. I took multiple trips to Albany, unfortunately, to oppose bail reform. I got into some pretty heated arguments with people like Carl Hastie and Andrea Stewart-Cousins opposing bail reform. And even when it was passed, we continued to fight. In fact, before it was passed, they included an amendment in the bill that they called the Sini Amendment, which included murder conspiracy as conspiracy 2 with the object of being murder in the bail statute. And we fought for more changes in April, and we're going to continue to fight for more changes. You're just lying about this, that we somehow were in favor of bail. You're playing politics.
Thank you. We're going to move forward with Mr. Tierney's second debate question. Dating back to the 18th century, legal scholars have said it is better that 10 guilty persons escape than that one innocent suffer. If you become a member of the District Attorneys Association of the State of New York, would you actively work against that organization's efforts to curtail the enacted discovery reforms that enhance transparency and fairness in plea bargains and trials?
Is the question with regard to the District Attorneys Association or District Attorney?
If you become a member of that association, would you work against that organization's efforts to curtail the enacted discovery reforms that enhance transparency and fairness in plea bargains and trials?
I don't have any problem with, I don't know what that organization's policy is on those things, but I welcome transparency in plea bargaining and discovery and turning materials over for the defense. Because it's something that I've practiced my entire career, and I am known as a prosecutor who complies with those statutes and readily complies with those statutes, because the truth is, if the case is a proper one, the truth will always be on the side. And it's interesting because he's talking about transparency, but there was a case, Weldon Drayton, where his chief of his public corruption bureau showed no integrity and hid things from the defense to the point where that case had to be dismissed while the jury was in the box. You know, that's not transparent, that's not effective, that's not ethical. So I will use my experience as a 27-year prosecutor to do what I've always done, to prosecute aggressively, to prosecute fairly, and to comply with all of the discovery and disclosure laws.
So you didn't answer the question. There's an entirely new discovery statute, and it's putting victims and witnesses' lives in danger. Do you agree with that discovery statute or not? Our position is that we don't, and we're going to work with stakeholders throughout the region to change the laws, do everything we can to change the laws to protect victims, to protect witnesses, and allow us to build these cases. It's as simple as that. It's important.
Well, that aspect of the discovery law, the disclosure of victims' names, as a gang prosecutor, as an actual gang prosecutor, I know that that's a disaster. And what we would do in Brooklyn, before we turned any material over, we would work, and I would have my assistants, who I oversaw, create these 20, 30-page protective orders, and we would present them in court with the discovery, and we would redact all of the necessary, all the personal information of the victims, and we fought in court for that. But we were active, we were aggressive. I brought resources to bear in the courts, and we did that in Brooklyn. You don't do that in Suffolk. You don't protect your witnesses. You don't seal your witnesses' names. So I'm certainly going to fight against that legislation, but I'm not going to wait for that legislation to change. I'm going to act in court, and I'm going to protect my witnesses like I did in Brooklyn, like I did in Eastern, like I did in Suffolk County.
Thank you. We'll move on to debate question number 3. Mr. Tierney, your debate question number 3 reads, it is argued that the cash bail system disproportionately impacts people of color, fueling a pervasive problem of structural racism in our criminal justice system. Black and Hispanic Americans are more likely to be stopped by the police and are more likely to be poor and unable to raise bail funds. The purpose of bail reform was to address these inequities. On your website, you promise that if elected, you will fight to repeal this bail reform. What do you say to those people of color whom this reform was designed to protect?
Okay, so is he against bail reform or for it? So
It's been very clear.
Stop talking.
He just asked me a question. It's very clear we have opposed bail reform and worked very hard to get it changed.
Gentlemen, this is not going to turn into a free-for-all. I'm going to ask you, yes, you have posed questions to each other. I would ask you to wait until your allotted time, which each of you will have. First person who's asked the question has 2 minutes. The next person has 2 minutes to respond, and the original person who asked the question has a full minute to rebut. If somebody asks you a question directly, I would ask you just treat it as a rhetorical question until your time.
Mr. Tierney, you may go forward with your answer.
Thank you. So apparently we're not completely against bail reform, but Be that as it may, when we talk about bail reform, I think the bail reform statute that New York has is a Frankenstein monster, and there are many components from the federal system and from other states. And you talk about cashless bail, you talk about a lot of things. I worked in the federal system with cashless bail. Cashless bail in and of itself isn't a problem. You could administrate cashless bail as long as the legislators in Albany do not take the discretion out of the court. And by that I mean, under our law in New York State, the bail reform law, judges and prosecutors and litigants, they can't consider significant factors. The number one factor that I would consider is dangerous to the community. A guy like Justin Smith, you've got to keep him in bail because he's a danger to the community. So if you are allowed to consider dangerousness to the community, risk of flight, and a lot of other relevant factors, whether it's cash bail or bond or whatever it is, that's less important. The most important aspect is the litigants should be enabled, not have their hands tied by the legislators in Albany, and be able to consider the relevant factors so an appropriate bail could be set, and there shouldn't be absolute prohibition to bail in certain cases.
So a good model to use would be the federal bail statute, where you consider dangerousness or public safety, however you want to phrase it, and give judges the discretion to hold people based on the variety of considerations, the strength of the government's case, the dangerousness that the defendant poses to the community, all the individual characteristics. So I think the federal model is the model that is the best model to put forward. That's what I wrote in the op-ed before the bail legislation was adopted. I urged the state legislature to consider the federal model. If you're going to eliminate cash bail, you have to have a dangerousness or public safety component in the bail statute. With respect to the cases that you've been lying about in public, these are cases that have a public record, whether it's Creighton, whether it's Smith, whether it's Mansfield, whatever case you reference. Whenever we start peeling the onion back, we realize that you're just lying. You're lying about the facts of the case. We've asked for bail in cases. Sometimes it's denied. Sometimes the defendant posts bond. And the people of Suffolk County are not going to fall for these press conferences where you're literally standing on the backs of victims to advance your own political campaign. Particularly in the Mansfield case, when you were talking about bail and indictments, you literally disclosed the name of a sex crime victim. I mean, that's disgusting, right? And then you lied about her case. Not to mention that the ADAs who handled that case, and I can't get into all the details, and you can appreciate that case was handled entirely appropriately. I mean, you owe that victim an apology.
Mr. Tierney?
It's interesting that, the earlier question, he talked about how he protects victims' identities through protective orders, but yet that victim's name was disclosed. It wasn't disclosed by me, it was disclosed by the district attorney's office, because I can't make sealing orders. You could ask for protective orders. I'm not DA yet, and when I am DA, I will make such sealing orders, okay? And the reason why a DA has to look out for the victims is because they have the apparatus, they have the mechanism, they have the access to the court, so mistakes don't happen. So the DA's office, first and foremost, has to work to protect victims' rights. You failed in that case. Not only did you fail in the case with regard to the disclosure, but you failed in keeping the subsequent victim, Frania Espinal, safe. If you think that not indicting an individual who has a violent weapons case and a violent strangulation case and allowing him to stay out for 5 months so he could murder a second person, if you think that's proper, well, then you really need to go.
Thank you, Mr. Tierney. District Attorney Sini, your debate question number 3 reads, organizations, including the New York Civil Liberties Union, and Newsday have filed lawsuits to enforce the Freedom of Information Law. These lawsuits seek access to police misconduct records relating to investigations, regardless of whether that investigation resulted in discipline. Do you think this type of open access enhances transparency and the fairness of the criminal justice process?
So there are two different issues, so let's just be clear. There's the FOIL process, which 58 has been repealed. There's the FOIL process, and government records should be, for the most part, transparent and disclosed, as long as they are properly redacted to not put anyone at risk, their own physical safety at risk. But in terms of criminal prosecutions, this is something that we're working very hard on. We believe that there are judicial decisions out there that interpret our giglio obligations way too broadly, and that's why we recently filed an Article 78 in Suffolk County. And we don't want to see prosecutions become sideshows about exonerated and unfounded allegations of police officers that have nothing to do with the officer's credibility or the case. It's important that we don't allow perhaps well-intentioned legislation actually jeopardize public safety. So this is something that I'm working on currently in Suffolk County. I'm working on it with my colleagues throughout the state. This is another issue, whether it's an intended or unintended consequence of the discovery statute. We need to protect witnesses, we need to protect victims, and then when we actually go to trial, we have to make sure that the case is being tried appropriately and is actually about the crimes that are charged.
Thank you. Mr. Tierney, would you like a chance to respond?
Yes, thank you. So I think that with regard to that law, I think the pendulum has swung far too far. And when you talk about disclosure of stuff that affects public safety, disclosure of information that really has nothing to do with credibility, just meant to embarrass or demean a witness, and really has nothing to do with their ability to do their job or to be truthful, that has to be guarded against. And so until there's a legislative fix, you've got to work. You've got to work to make the appropriate protective orders. And again, we made those protective orders in Brooklyn. These orders aren't being made in Suffolk County. Our protective orders were routinely 20, 30 pages long. And what's happening here, we have in Suffolk County, you're having district attorneys say pretextual statements of readiness. We're ready for trial. We don't know who our witnesses are, but we're ready for trial. That's pretextual, and that's why there is a number of cases, many cases being dismissed because the district attorney's office can't comply with these requirements. And now these requirements are onerous, but what you have to do is you have to steer into them, and you have to bring back the resources of the office into the courtroom. You have to bring your most senior assistants into the office to work through these cases, to do these protective orders, because until there's a legislative fix, you're going to continue to lose cases.
Right. We routinely make protective orders protecting our witnesses and victims. There are people in this room who spend hours and hours every single week doing just that. We bring some of the largest prosecutions in the state of New York, if not the country, on in drug trafficking and gang violence. We've brought over 60 OMT charges since I've been DA, and many of those cases involve very complex investigations, and they involve protective orders. We've indicted hundreds of MS-13 gang members, and those cases involve protective orders. It is integral that we do everything we can before the legislation is changed to protect our witnesses and victims, and that's precisely what we're doing in the office, and that's why you're seeing these big cases made, and that's why you're seeing reductions in crime, and we're going to continue to do that. In the meantime, we're going to fight to change the law, because the law needs to be changed. We need better laws that protect our communities.
We will move on to debate question number 4. Debate question number 4 will be asked of both candidates. The question reads, both campaign websites tout the candidate's strong anti-gang position and accomplishments. District Attorney Sini, we ask you first, what did you do?
So when I became police commissioner, one of the first meetings I had was, it was in late 2015, and we had a few missing boys. And one of the first briefings I got as, at the time I was actually deputy police commissioner, was that we believed that these missing boys were actually homicides. And as time went on, that became even clearer. We developed a gang eradication strategy. And that strategy involved hundreds of arrests, both big arrests and small arrests, because we believed that the arrests would disrupt the operation. It also involved bringing cases to our partners in the U.S. Attorney's Office. It also involved working with the Department of Homeland Security to detain gang members who are here illegally and deport them. It involved investing in gang prevention strategies. And we saw a significant decline in gang violence. And we brought that strategy into the DA's office, and it culminated in December of 2019 in one of the largest MS-13 takedowns in U.S. history. 96 defendants were indicted here in Suffolk County, including for murder conspiracy, weapons charges, and other offenses. And we shared intelligence because it was a 2-year wiretap investigation of over 200 phones. One of the largest wiretap investigations I've ever heard of. And we shared intelligence with jurisdictions all throughout the world, and it netted over 300 arrests. Officials from Guatemala came to Suffolk County to thank us for our collaboration because we were able to actually solve murders in Guatemala. This case was significant. In fact, as has been disclosed on the public record, there are communications intercepted over this wiretap where you have gang members talking about how they need to end the New York program because of the pressure from law enforcement. And I know you want to go around town and say this isn't an important case because we're pleading the charges out, but that's not true. We have 4 murders, we have murder conspiracies, we're getting significant sentences on many of these cases, and now the goal is to ensure that MS-13 doesn't reconstitute, and we're going to get that done.
Vanessa Argueta, Diego Torres, David Sandler, Nestor Moreno, Mario Alberto Canton Quijada, Esteban Alvarado Pena, Derek Mays, Keenan Russell, Kayla Cuevas, Dewan Stacks, Nelson Rodriguez, Justin Livacora, Jorge Tigre, Michael Lopez, Julio Vasquez, Jairo Vasquez, Enston Cerrone, Ricardo Cerrone. These are just some of the murders that my team in the federal government worked on and solved. We solved just about 50 murders. We brought deadly MS-13 murderers to trial. We convicted them, and they're serving life, 30, 40, significant time in jail. Okay, I have a track record. You could check my track record. Okay, he seals his pleas, but he doesn't seal the press conference. So when he has a press conference, he talks about how deadly they are. He talks about all the murder conspiracies and all the things they do. And then when he plea bargains them out to what amounts to time-served sentences, he asks that the sentence be sealed so the public can't see. These 96 defendants, okay, 46 of them were MS-13 murders. That's 92 murders. How many murders did you charge them with? What did you do about those 92 murders? How did you try to solve those 92 murders? Give us names. Give us sentences. I could give you names and sentences all day long. You have never once given a name or a sentence of any of those cases. 96 defendants. 300 defendants. What are their names? You don't even have to give us the names. Give it to a judge. You could give them the name, what they were charged with, and what they were sentenced with. Give us for all 396, and I'll be satisfied.
96 defendants were indicted in Suffolk County. That's real. There are court cases involving those defendants. There are people in this room who represent some of those people. Some of those cases are completed. Some of them have received sentences. Some of the cases are still pending. And you're talking about sealed pleas. I think you and I both know that it's appropriate in many circumstances to seal pleas. We know what that's about. You know, I'll never forget when I found out, when I was told when Nisa Mickens and Kayla Cuevas were murdered, because I was the police commissioner at the time. And I'm the one that met with the families. I'm the one that was in the room, in the community rooms, ensuring that the community knew we had their back. I was the one in the room that developed the gang eradication strategy that worked, that your previous office knows worked and was part of. I'm the one that had to get the job done as the commissioner of one of the largest police departments in the country. And we did get the job done. And then we brought that strategy into the DA's office and delivered again. And we'll continue to deliver.
Mr. Tierney, since this is a joint question, if you want 1 minute.
Please.
for rebuttal.
So, not one name, not one sentence, okay? If it's okay to keep a sentence, to keep a case open for the press conference when you could have your splashy press conference and talk about all the deadly MS-13 members and all the murder plots that you foiled, if that's okay to not seal, then you could certainly seal the sentences, because not all of those sentences are cooperators. The only reason why you would seal a sentence is cooperators, unless you're saying that all 96 of those defendants pled guilty to cooperation agreements, which is a whole nother disaster. But when we were, and I can tell you, I worked in that MS-13 program, that unbelievably successful MS-13 program, and we were completely separate and apart from Suffolk County, and the district attorney had absolutely nothing to do with the success of our program. He never prosecuted a case, and he never went into the grand jury, and he was never in court when we were fighting the good fight against the MS-13.
I'm going to move forward to debate question number 5. Mr. District Attorney, your debate question number 5 reads, how do you answer those critics who allege that you prosecute by press conference, meaning that you hold media events to inject into the community and jury pool adverse information about an arrestee?
So we provide press releases, or in some instances, press conferences about significant events that occur in the criminal justice system that is on the public record. And we have an obligation to do that, and we do it appropriately within the ethical rules. You know, in the past month, my opponent has actually held more press conferences about cases than I have. And in one of them, he revealed a sex crime victim's name and is now not taking responsibility for it, and lied about that case, and has lied about a number of other cases, and is attempting to advance his political campaign on the backs of victims. We hold press conferences when we indict a case, and we talk about the facts on the record, when there's a conviction, whether by trial or plea, or when there's a sentencing. When there's a significant event that's on the public record, we will notify the public, and that is the right thing to do.
Mr. Tierney, would you like to respond?
Yeah. With regard to press conferences, the vast majority of the office's press conferences are at the time of the arrest and the arraignment. That's the easy part. And there's an unbelievable dearth of information at the time of sentence, because take Operation Pay Dirt. You had 30 individuals, and he talked about all of the bad things that everyone did. Out of those 30 and he talked about how it was a conspiracy and how everybody was guilty, and how they were talking about dumping these pollutants on all of these properties, and they all worked together. There was no press conference with regard to all of those defendants, because out of those 30 defendants, only one went to jail. The individual who they had probable cause to arrest 2 weeks into the case. Only one other person pled guilty to a felony. 20 individuals pled guilty to a violation. So what you have is a situation where he points everybody with a broad brush, says everybody is a pollutant, everybody's the worst person in the world. And then when the cameras leave, he pleads everybody out to non-criminal offenses. That's unethical. It's unethical under the ethics laws that govern prosecutors, that govern attorneys. What matters is the results in court. Tell us what happens with the police. Tell us what happened to these MS-13 members. You don't give us facts. You give us splashy press conferences, and then you don't follow through.
So on Operation Pay Dirt, we literally received the most significant sentence on the defendant, who was the ringleader, 2 to 4 years in prison, in an environmental crime case in the history of Suffolk County. And then we convened a special grand jury because we do understand that we need stiffer penalties for polluters. And that grand jury issued a special report that made recommendations to stiffen penalties, and the legislature adopted those recommendations and changed the law. So not only was Operation Pay Dirt a significant case, and we were also able to clean up all those properties with asset forfeiture, but we were able to change the law as a result of that case and hold polluters accountable. And on the MS-13, we've taken pleas. We have 4 murder cases. We have 10 murder conspiracy cases. We've taken pleas on several of them. I can tell you that I know there's a 10-year sentence. There are significant sentences on many of these conspiracy cases. And we will continue to make these cases and hold these gang members accountable. You're just misstating the facts that we don't have sentences or convictions on these MS-13 gang members.
Tim, by definition of your own indictment, you say that any MS-13...
I'm sorry.
Oh,
That was Mr. Sini's rebuttal from your...
I apologize.
The timer. We're going to move on to the next debate question posed to Mr. Tierney. Mr. Tierney, your debate question number 5 reads, civil disobedience as a route to reform has deep roots in the American criminal justice system. In our county, we have seen peaceful protests and protests that have turned violent. What would your position be about prosecuting nonviolent, civilly disobedient, reform-minded protesters?
Well, I can tell you I won't do what you did with Devon Toney. Devon Toney was an individual who was protesting in front of your house. The police department was called, the DA squad was called, the entire 3rd precinct was called because this undesirable person was in your neighborhood. The police talked to him. They decided not to charge him, and everybody peaceably went their own way. Somehow, remarkably, without a court proceeding on the record, Devon Toney found himself in jail, despite never having been arrested for a crime. So no one knows what caused Devon Toney to be thrown back into jail. There was no record of it. The case proceeded to trial. Devon Toney and his co-defendant were found not guilty. So certainly, when it comes to civil disobedience, I will be respectful of people's rights. I might not like it at times. It might not be unpleasant, but I will follow the law. And I will follow the law for cases involving me and my staff, as well as anybody else in the community. And if somebody's being unpleasant, but it's not a crime, I will not throw that person in jail. I will not have my chief assistant prosecute that person and spearhead the prosecution, which ultimately led to being unsuccessful.
So you're misstating essentially all the facts in that case. You are right that I had a protester come to my house who had an open criminal case. And this happens often. I also receive death threats often. It's part of the job. It is what it is. In this case, you are correct that that person was not arrested for protesting in front of my house. He was later arrested for not appearing in court on a bench warrant. And he was also convicted of several crimes at trial, and I believe he's still awaiting sentence. This is an individual who killed someone in a bar and was convicted of manslaughter. This is an individual who assaulted a police officer and incited a riot. He was not arrested for protesting in front of my house. He was arrested for decisions he made, including making threatening remarks against prosecutors and a judge. That's why he was ordered to come to court, and he didn't show up. I think it's reckless to continue to comment on cases and misstate the facts, particularly, Ray, when you're talking to family members of murder victims at community meetings. When you don't have all the facts, I ask that you exercise some prudence and some discretion, because you can get someone hurt. Whether it's standing on the backs of victims to advance your political campaign and lying about their cases, whether it's talking to family members at community meetings about an open homicide case. We're doing serious work in the DA's office, and we need to protect our victims, we need to protect our witnesses, and not use the cases for political advantage. You've now held press conferences on at least 3 cases, misstating facts left and right. It's not safe.
It's amazing that he's talking about the backs of those 6 overdose victims. You know, what I'm concerned with is preventing people from getting hurt in the first place. You failed to prevent those 6 individuals from getting hurt. Now they're dead. You failed to prosecute Darren Mansfield. Now Frania Espinal is dead. And with regard to Devon Toney, you're talking about his criminal history. So does that entitle you to throw him in jail even though he didn't commit a crime? You know he wasn't found. He was found guilty of a misdemeanor. His co-defendant was won at trial. He was acquitted, and there was no notice of the record. He did not have representation at the bail revocation hearing. You were a bully. You did not give him the rights that every American is guaranteed, because you were mad because he had the temerity to go to your house. And what I'm going to do is I am going to treat every single criminal defendant and every single victim the same.
Thank you. We're going to move forward to debate question number 6. Mr. District Attorney, your debate question number 6 reads, as a matter of integrity, you have a policy not to accept campaign contributions from defense attorneys. In light of your own policy that eliminates the conflict of interest you perceive, why do you refuse to meet with defense attorneys on major cases in which you are the ultimate decision maker?
So you're correct that we do not take money from defense attorneys that do business in Suffolk County. And the reason for that is because when we came into this office to reform the office, one of the major concerns was that there was special access, special treatment given to certain defense attorneys. Some folks had access and some didn't. And the idea of a district attorney taking money from folks who are practicing law in Suffolk County, at a minimum, gives the appearance that they'll have special access. Now, in terms of meeting, it's the same principle. I have a team that is extremely accessible to the defense bar, whether it's at the line level, the boss level, the division chief level, and I think it's a best practice to let them gather the facts, have the meetings with defense attorneys, and then we, as an office, make a decision. And that way, there's no favoritism, there's no special access. I'm not making decisions, oh, I'll let this defense attorney see me, but not this defense attorney. We think that's the fair process. Now, it's certainly, I believe, because I've spoken to several defense attorneys who appreciate that policy. And I think it depends on who had access under the previous administration and who didn't have access under the previous administration. And that's a policy we're going to continue into the second term.
We're all colleagues here, we're all attorneys, but anyone in business knows, how can you come to a resolution if you refuse to meet with the other side? It doesn't make sense. And everyone here knows that it's very difficult to get an audience with the district attorney, impossible, and it's very hard to get a decision from the underlings. I am going to change that when I become district attorney. I am going to be open. I am going to meet with everyone because you are all colleagues. I am not above you. I anticipate you will comply with your ethical obligations as well as I will. We will be professional. It won't be presumed that one of us is corrupt. That's insulting. And we will get business done. If you wait for the courtroom to get business done, things back up, and that's what we're seeing. And with regard to not taking money from defense attorneys because it takes the appearance of impropriety, the district attorney has, by the end of this campaign, the Suffolk County PBA is going to spend well over $500,000 on his campaign. What about that appearance? What about that conflict of interest? What about accepting money from or getting benefits from vendors? 110 Marcus Avenue, okay, was a rental agreement that was changed under this current administration. The individual, and it took a lot of digging, but the individual who owns 110 Marcus Avenue is an individual by the name of Peter Ferentinos. Peter Ferentinos is a campaign contributor. Business as usual.
So you're literally taking hundreds of thousands of dollars from political party bosses who gave you a job to run against me. That compromises your independence. In terms of the PBA, I'm proud to have the support of law enforcement. And we've unfortunately have had to indict police officers and charge police officers, at least 6 of them. And so this notion that taking money from the PBA will affect how we hold police accountable just is belied by our record. We follow the evidence and we do the right thing. I think it's a better practice not to take money from defense attorneys. I think it certainly at least has the appearance of impropriety in terms of how you make decisions, giving certain defense attorneys access. And I'm proud to have the support of law enforcement. And despite their support, we have held them accountable.
Thank you. Mr. Tierney, your debate question number 6 reads, you've been an executive assistant district attorney in Kings County's district attorney's office and otherwise out of the Suffolk County district attorney's office for some time. How do you reply to people that say you're out of touch with Suffolk County State Court criminal practice?
Well, I resigned from the Brooklyn DA's office in March of this year. Up until that time, I've been a prosecutor for 27 years. Prior to that, I was a prosecutor for 13 and a half years in the Suffolk County District Attorney's Office. This district attorney has been a state court prosecutor for 3.5 years. I've tried countless cases in Suffolk County, in state court. The district attorney has tried none. So I've forgotten way more about Suffolk County criminal practice than you ever learned. So I am well versed in the criminal procedure law, the bail reform, through my work in Kings County, and over and above that, my body of work as an over 26-year prosecutor brings an unprecedented amount of experience as far as prosecuting cases on all levels. Not only knowledge, but relationships. I have relationships all across law enforcement. I'm going to bring all of those to bear to really increase the level of practice in the Suffolk County District Attorney's Office.
So it's important to realize what this job entails because you're managing one of the largest prosecutor's office in the country. And it involves making hundreds of decisions each and every week. Most of them relate to personnel, budget issues, grants, case management, how to allocate resources, how to run an organization that is of over 400 people with a 40 million plus budget. You don't have that experience. You constantly talk about how you've done more trials than me, but you're not realizing what this job entails. You're not applying to be a trial assistant. You're applying to be the CEO of one of the largest prosecutor's offices in the country. I have that experience. I have that track record, both in terms of running the police department and now running the district attorney's office. We've brought this office very far. We've recruited over 100 people to come into the office. We're advancing people in the office. When I came into this office, people were stuck in district court for like 5 years. Now we're moving people on a monthly basis. We've invested in our training program like never before, and a lot of that is coming from bottom up. We have these working groups that give management the ideas to improve the office. We've invested in technology like never before. When I came into the office, they had virtually no digital case management system. We've digitized the entire office in just 3.5 years, utilizing a system called PCMS. We're producing discovery to Defense Counsel via a cloud-based system. We're investing in data analytics. We're investing in crime-fighting technology, whether it's DNA technology, advanced electronic surveillance technology, drug detection technology. And all these issues and all these accomplishments, all these things require management experience, and a vision for the office. You've not set out a vision for the office. While I've moved the office into the 21st century and will continue to do that, in part by continuing to recruit talent, investing in technology, and continuing to do the great work for the people of Suffolk County. You're running to be a CEO, not a trial assistant.
I have more trial experience than you because you have none. I was a executive assistant district attorney in Kings County. I ran 3 bureaus. I had investigators. I had crime victim advocates. I had analysts. I had assistants, and I coordinated all of those various individuals with the NYPD, and we coordinated cases. And I also worked cases, and I made sure that my assistants had the tools necessary to do the job. You talk about people moving up from district court quickly. That's because people are fleeing the office at a record rate because morale is terrible. You talk about a paperless system. The paperless system, the clerks will tell you, has serious problems. Also, you need the proper technology. You need experience for that. We don't have ShotSpotter in Suffolk County. That's outrageous. Shots fired cases don't get reported. Or investigated. We don't have proper infotainment.
Sini, that was Mr. Tierney's opportunity to rebuttal on the question. That was the end of that round.
We're going to move forward to debate question number 7. Debate question number 7 will be asked of both candidates. The question reads, with COVID-19 showing no end in sight as we approach another winter, we are seeing employers mandate the COVID-19 vaccine. Mr. Tierney, we ask you first, if you are elected district attorney, would you support a vaccine mandate for your staff?
I don't think that I am qualified to issue a vaccine mandate for my staff. I am not a public health official. I have no medical background. So I would rely upon the medical experts to provide that guidance and that information to my staff. Certainly, I would then follow those mandates and that guidance by those experts. I will say this, that I was assistant district attorney in Kings County during COVID. And during that time, with the taking of the street crimes unit off the streets, COVID, closure of courts, criminal justice reform. From a very short time, Brooklyn became a very safe place to a very dangerous place. And this was in and among the time of COVID. And we were working day and night to try, because what you have to do in cases, you can't wait to gather 96 defendants for a splashy takedown. What you need to do is you need to take these dangerous individuals off the street as soon as possible. That's what competent prosecutors do. So that's what we were trying to do, and we were being told by health officials that you can't do that because of the COVID crisis. And what we ended up saying is, listen, the crisis is people getting shot. We're going to deal with that. We're going to try to comply as much as possible, but public safety as far as violence in the community, that has to come first, because as district attorneys, as police officers, we're first-line workers.
So in Suffolk County, we were able to oppose the release of inmates as a result of the COVID crisis and COVID pandemic, unlike the city DA's offices. And that was in part because of the great work that the sheriff is doing in the jail. And in terms of the specific question, in terms of vaccines, the county is going to set that rule, and we're going to follow whatever protocols they adopt. But I just want to explain or give actually my thanks to the office, because what we did during COVID-19 was phenomenal. We were able to essentially go in a moment's notice to a completely remote working model. And then we were able to bring that back. So we were one of the first DA's offices to go virtual. And not only migrate everyone home, but then also start virtual court. We did that in partnership with the courts, obviously, and the defense bar. And then we were one of the first offices back in the office, doing the people's work in the office. We were one of the first offices with grand juries back. It took a lot of work, a lot of investment in technology, a lot of communication, a lot of coordination, and a lot of collaboration with the courts and the defense bar. And it was our team that was able to get that done. And we kept the system moving without jeopardizing public safety, without releasing inmates from jail, and continuing our cases. And we've been working diligently to get through that COVID backlog with much success, whether it's indicting cases or trying cases. And I'm certainly proud of the team that worked so hard to ensure that we didn't miss a beat during the COVID-19 pandemic, because we didn't miss a beat.
Thank you.
I get-
We will move on to
Do I-
debate.
Wasn't it to both?
According to both, that question was for both candidates.
Yes, I didn't have my rebuttal.
Sorry, Mr. Tierney can continue. Okay. Mr. Tierney, my apologies.
No, not at all. It's confusing. So when I was working in the Kings County District Attorney's Office in the Violent Criminal Enterprises Unit, in the gang unit, we dealt with the most violent offenders in Brooklyn. So, what we did was we continued to work through COVID. We continued to keep these individuals in. We opposed all of the bail applications on COVID grounds because of the nature of the crimes charged and the individuals which we were prosecuting. And we were highly successful, if not 100%, then very close to it. In addition to that, while the courts were closed and because there was a lot of shootings that were occurring, we instituted felony exams, and we had our assistants come in at my direction, and we were doing virtual felony exams virtually nonstop through COVID, even before the grand juries came back. And that was really, owing to the tremendous work by the young assistants in Brooklyn.
Mr. Sini, do you want to reply at all?
The work that was done was incredible in terms of whether it was a virtual exam, good cause applications, or when we did get our grand juries back, getting in there, coordinating the schedules. They did a phenomenal job, and we're proud of the team. And it just goes to all the challenges that we've had. We're doing a lot of surveys, including anonymous surveys, and this is important because you get feedback from the people in your office. And if you run an organization, I would suggest, if you're going to read an anonymous survey, pour yourself a glass of bourbon before you before you start that survey. But it gives you some great ideas about how to continue to strengthen the office, and that's what we're doing. Ray talked about morale. I mean, morale in law enforcement is at an all-time low in this country, including in this, and particularly in this state. And what's happening in other DA's offices is just not happening in Suffolk County. It's not perfect, I understand that, and we're continuing to deal with issues that were caused by the new laws and by COVID-19. But we are undoubtedly in a far, far better place than our sister offices throughout the state.
Now we will move on to debate question number 8. Mr. Tierney, your debate question number 8 reads, many who have served in the Suffolk County District Attorney's Office under both Mr. Spoda and Mr. Sini have praised the transparent and supportive leadership that Mr. Sini brought to the office. This praise comes from all levels in the District Attorney's Office. Many of the Assistant District Attorneys will continue on if you are elected. What do you say to them about the leadership style of a Ray Tierney administration?
Am I just supposed to assume the truth of that question? Because I dispute it, but
This
be
was
that,
submitted from our membership.
be that as it may. My leadership style is hands-on. I've never been handed anything in my life. I've never been given lofty positions at a young age because of political connections I made. I remained politically independent as a young prosecutor. I've only become political the last 3 months or the last 6 months to run this office. So I'm going to be very hands-on because I know the job. I know from the very lowest to the very highest, from the U.S. Attorney's Office, from the Suffolk County District Attorney's Office. And when I was a executive assistant in Brooklyn, I brought that experience to bear, and I was able to really help the assistants with their professional development. I was able to help them with regard to developing relationships and helping to further cases along. And we were able to do really great things because I was hands-on, I was available at all times, I was in the courtroom, I was available to step in if need be. And not only am I going to be like that, but all of my supervisory assistants are going to be like that. We are going to work. The Suffolk County District Attorney's Office should be the greatest job you ever have. And the way you do that is you protect the people, you work together, and you strive to do the best you can in every single case.
Would you like to respond?
Sure. Well, first of all, just in terms of your political independence, for someone who hasn't been involved in politics, you certainly jumped in to the deep end. And you know, the fact of the matter is that the political party bosses have chosen you, and they're funneling hundreds of thousands of dollars to you, and you work at a political patronage mill so that you can run against me. I take a lot of pride in that, because what that means is that the political party bosses know they have no influence over the DA's office. It's very simple. In terms of management, you know, this is something that we take very seriously in the DA's office. We're investing in management training. I mentioned about the surveys to get direct feedback from folks throughout the office, including support staff. In terms of my leadership style as DA, and the assistants will tell you this, it's a combination of meetings and walking the halls and talking to people about how their day is going. We have a structure where the bureaus meet with me directly every 2 weeks. When we have high-profile cases, we have scheduled meetings on those high-profile cases. We have chiefs meetings often, and there is collaboration. I mean, that's really the key, and it's important to continue to invest in your workforce in a number of different ways, whether it's promotions, continuing to advocate for the office and hire folks and allow advancement, whether it's investing in tools like technology, and we're getting it done on multiple fronts in the office. There's a lot of challenges in 2021. There was a lot of challenges in the last several years, but people are coming together, working hard, and the office is strong.
So,
Mr. Tierney is
Okay, no, it's okay, it's okay. So my opponent talks about political independence. So let's talk about his political independence. After 4 years in the U.S. Attorney's Office in which he never tried a case, he comes out to Suffolk County, he runs for political office, and he loses. He gets rewarded by becoming assistant county attorney in charge of public safety, in charge of the police department, and in charge of the district attorney's office. He hides under his desk for 16 months, does nothing while Spoda and Burke run wild. He gets rewarded by becoming police commissioner. He promises he's not going to use it as a political platform on which to run for district attorney, and he does just that. But before he does that, he lets 84 IAB complaints lapse. That means they're run without being adjudicated. That's independence, okay? And then he becomes district attorney, okay? And he wants to talk about my independence. I have been a prosecutor for 27 years. None of my donors will give me money. They're much more comfortable giving the parties money because they are afraid from retribution from you and your chief investigator.
Mr. District Attorney, your debate question number 8 reads, you initiated a system of vertical prosecution in the district court. What was your purpose for making this change, and do you think it has been successful?
So you keep peddling in lies, Ray, and it's important to correct some of your misstatements. First of all, despite the fact that we're running to be a CEO of one of the largest prosecutors' offices in the country, I was fortunate enough to work in one of the best offices in the country, the U.S. Attorney's Office for the Southern District of New York, and try numerous cases, including 3 murder trials. And this idea that I don't have trial experience is just not true. The reason that I became police commissioner is very simple. The county executive needed to right that ship straight. He asked that I go there and do it, and we delivered. We did a top-to-bottom assessment of the department. We put the right people in the right places for the right reasons. We reformed internal affairs and did not allow disciplinary cases to lapse. We started the first ever body camera program in Suffolk County. We enhanced community relations. We created the Real-Time Crime Center, which is state-of-the-art technology in terms of fighting crime, and has been recognized by DCJS as such. And then it became clear to me that if we wanted to continue to make progress in the criminal justice system, we had to reform the DA's office. And I actually did not want to run at first, and I tried to recruit someone. And his name's David Kelly, former U.S. attorney and right now in the private sector. And it turned out that I stepped up and ran, and I won. And then I got to work in the DA's office and reform that office. And you can make misstatements, but it doesn't wash away what has happened over the last several years.
What's happened over the last several years is that crime is rising steadily and continuing to rise. You say you had 3 murder trials. I still haven't heard the names. Have you done an opening? Did you do a closing? Did you do a rebuttal summation? Let's hear. Tell us what you did. You said that you didn't allow 84 IAB complaints to lapse, but you did. It's a matter of record. You're saying you're independent, yet the county executive tapped you, a 34-year-old individual with no police experience, to become the police commissioner after a supposed nationwide search. And who did he find? He found the guy living in the same neighborhood as him. Nobody buys it. Nobody buys that a 34-year-old individual with absolutely no police experience is the best person for the job of police commissioner. That's ridiculous.
So look at the record. Look at the record. What did we accomplish? And I just laid that out. The department was in scandal. We restored integrity to the leadership of the department. You're saying crime is at an all-time high. It's at an all-time low. That doesn't mean we don't have public safety challenges. We do. Whether it's the drug epidemic or gang violence, or a number of different issues. But you just say whatever you want without any regard for the truth. Crime is at a historic low. And in terms of gun violence, where you see triple-digit increases throughout the region, you have we have 3 more shooting victims this year compared to 2020. And look, 1 shooting victim is 1 too many. But you have to put this in context. Law enforcement is doing a tremendous job of keeping Suffolk safe, and we'll continue to work with all of our partners to do just that.
Thank you. We're going to move on to debate question number 9. Mr. Tierney, if you can go back and change one decision you made as a prosecutor, what would it be?
I just want to go back to that. My opponent said that crime is at an all-time low, and then he just said we have more shooting victims this year than we did last. So that's a contradiction in terms. And when I become district attorney, what I am going to do is I am going to start a crime strategies unit. I'm going to be open and transparent, and I am going to allow the public to see what is going on. I am going to map out the crimes, these index crimes, violence, murders, shootings, burglaries, and we're just like the NYP does it with CompStat. And we're going to release those statistics, so you don't have to believe him, you don't have to believe me, you have these statistics on a real-time basis. Here in Suffolk County, what is happening is we are being gaslit. We are not being told the truth. Okay, so what I'm going to do is I'm going to be open and transparent. You're not going to have to believe me. You're going to be able to see it with your own eyes. Because right now, what's happening is we're not investigating shot-fired cases. Okay, those are the precursors to the murders. Those are predicates for gang conspiracy cases. That's the meat and potatoes of any kind of competent district attorney's office. But here in Suffolk, we ignore them, because we want to protect the criminals and the politicians. I have no interest in that.
We have thousands, over 1,000 gun cases in the DA's office. You're saying the Suffolk County Police Department doesn't investigate shootings? What world are you living in? They absolutely investigate shootings. We assist, and then we prosecute those cases. And in many instances, we indict them, despite the fact that you're going around town saying we don't indict gun cases. The vast, vast majority of our gun cases, since I've been DA, have been indicted. It's just that simple. We're talking hundreds and hundreds of gun cases indicted. And we're going to continue to work with the police department. For example, when we saw the uptick in shootings in June and July, and this idea that we don't index crimes in Suffolk County and we hide the facts, just go to the police department's website and it will prove your claim false. And so when we saw that uptick in June and July, we worked with the police department to develop a strategy to reduce gun violence. And what happens? Gun violence decreases in August and September. So in the DA's office, we work with our local, state, and federal partners to keep Suffolk safe. We've been successful despite all the challenges, and we utilize a number of different types of technology.
I have to explain something. I think people in the audience understand, but in underserved communities, when shots are fired and people are being terrorized, they are not going to call the police. That's what ShotSpotter is for, because it'll create a record and it'll give in law enforcement a jump start to investigate these cases. So when I become district attorney, what I'm going to do is I'm going to have an integrated gang unit, and I'm going to have specific ADAs. They're going to be assigned to specific gangs. They're going to be working with a team of detectives as well as Suffolk County Police Department. And the second that that shot spotter goes off, we are going to investigate those cases, and we are going to begin to accumulate evidence. And the purpose for that is what we're going to do is we're going to develop large gang conspiracy cases. Large gang conspiracy cases like I did in Brooklyn. Large gang conspiracy cases like I did in the Eastern District of New York that marries violent acts with gang conspiracies, because that's how you get heavy sentences, and that's what the Suffolk County District Attorney's Office can't do.
Thank you. District Attorney Sini, I'm going to try and ask my question again. If you could go back and change one decision you made as district attorney, what would it be?
Yeah, so when you manage a large organization like the DA's office or the police department, you're making hundreds of decisions each week. And those decisions weigh on you, and there's a lot that goes into those decisions. And certainly when you're coming into an organization, particularly as an outsider, you have to learn quickly. And so we developed a number of different strategies to get to know the individuals in the office and we interviewed every single prosecutor before I even took office, between the election and January 1st. But there are challenges. So there are absolutely certain personnel decisions that we made that did not go as planned. That's not to say that the vast majority, which is well over 100 people that we've hired in just 3.5 years, 30% of which are people of color, by the way. We've increased diversity in the office dramatically from essentially 92% white to 83% white. So you're moving the needle almost 10 points in just 3.5 years. And we did that by simply expanding our recruitment pool and bringing in great talent. But when you expand your recruitment efforts, you're going to increase diversity. And so personnel decisions are some of the hardest decisions you have to make as a boss. So certainly there are decisions that we got right, and there's some we got wrong.
Do you want to respond to that at all, Mr. Tierney?
With regard to my biggest regret as a prosecutor, I think in cases you have situations where, every time you have a case, there are things that you think about that you could have done better. Cases that you hoped would have gone better. But I don't have a whole lot of regrets in my career. I think that one of the big things that I regret in my one of the things that I regret in my career was that as a young assistant that I wasn't I wish I was a little bit more bold my first or second year and really worked to try cases. Right when I got into the office. It takes you a while to get acclimated. So I wish I was just a little bit more bold in the beginning of my career.
Well, I didn't know Ray back then, so I don't know if he could have been more bold, but I'll take his word for it.
We're now up to debate question number 10, our final question for the evening. Mr. Tierney, if you were standing here 4 years from now, of what accomplishment of yours will you be most proud?
I think the accomplishment that I will be most proud of is that I would have reconfigured the office to take the resources of the office and put them more in the courtroom. We talk about onerous criminal justice reform and discovery reform. So really what I want to do is I want to take the most experienced prosecutors, those prosecutors, who are writing complaints currently, put them back into the courtroom, get them in there, inspire them to try cases, get them the resources, analysts, discovery expediters, so we can comply with these onerous discovery requirements, so we could move the cases forward. If there are, in April of 2021, there were over 100 criminal possession of a weapon in the second cases that went unindicted. That's too many. What you need to do is you need to give the direction, and you need to give guidance and resources to the assistants so they can prosecute the cases. Right now, you've got what was once called major crime. They're bearing the brunt of the burden. They need help. They need resources. So we're going to do that. We're also going to integrate that gang program like we talked about.
So one of our major accomplishments is to basically recruit over 100 people into the office to allow advancement. And so what I'd want to see is basically continued improvement in perfecting the personnel configuration that we have in the office, which means continuing to bring new classes in each and every year. We've been doing 20 plus ADAs each year starting in August or later in the fall. And then continuing to move people and advancing people throughout the office. And we've developed basically a process where we think we're able to get ADAs great experience and get them into places where the office needs them. So continue that sort of pipeline of folks into the office and make sure that each of the felony bureaus have the resources that they need. And also continue to invest in technology, particularly with the discovery demands that we currently have. Right now, we're actually experimenting with artificial intelligence to actually make it easier for the folks in our intake bureau, which is a new 24/7 bureau that liaisons with the police departments, to essentially import the information from the police departments into the DA's system, which is called PCMS. So continue to invest in that technology so that ADAs are empowered to focus on doing their jobs, which are enhancing their cases, getting ready for hearings, getting ready for grand jury, getting ready for hearings, getting ready for trials, and executing. And then, of course, there are specific goals that we have. There are particular cases that we want to complete. There are particular crimes we want to solve. And so we are going to be certainly busy in the second term. We have a lot of goals, but we'll get it done.
I just think that, not specifically with regard to what Tim said, but I think the other thing that I'd be proud of is, to utilize the resources of the office, whether it be forfeiture funds or otherwise, to invest in ShotSpotter, to invest in those cell site technology, to invest in cars. There's this program called an infotainment system, which when you plug the car's computer into that system, you can learn a tremendous amount of information about the car and the individuals who are in that car, accessing it through wireless and other means. So what I would be proud of is if I can spearhead the office and direct the resources of the office to obtain these things that other offices have, so we can do the type of cases that I've done my entire career.
District Attorney Sini, that question was the same question that you had answered. Is there anything you want to add before we close the debate?
Yeah, just in terms of technology. So we've invested, I've talked a little bit about the case management system, but on the crime fighting side, we've invested hundreds of thousands of dollars in crime fighting technology, both in terms of new servers so that we can actually have the infrastructure to do these wiretaps. In terms of drug detection technology, we purchased a mass spectrometer that allows us to identify analogs. We've invested in new DNA technology, including but not limited to the MVAC, which helps us extract DNA from surfaces that can be tricky to get DNA off of. And we've invested in software programs that are so sophisticated that the Department of Defense uses them to do our phone analytics. So if we're dumping cell towers and we have millions of data points of phone information, you actually have a software program that can start connecting those dots, right? We collect the dots, but the human brain cannot analyze 5 million data points. So we've invested in software to help us do that analysis. And that's allowed us to effectively build cases and keep crime low. And those are certainly priorities that we're going to continue in the second term.
Thank you. This concludes the first part of our debate. Now I would like to invite each candidate to present a brief closing remark, no more than 3 minutes. District Attorney Sini, the floor is yours.
Sure. So, look, we've been busy the last 3.5 years. And so we came in, it was a new administration. We had a sweeping overhaul in the criminal procedure law, a global pandemic, and we got the job done. We recruited talent. We've hired over 100 people in the last few years, and most of them are entry level, right? So we've hired 20 plus entry level ADAs in 2019, 2020, and 2021, and we're already hiring a class in 2022. And that's allowed us to move people through the office and address a lot of the personnel issues that we had when we inherited the office. We've also invested heavily in technology. We've digitized the entire office in just 3.5 years. And we're producing discovery to defense counsels via a cloud-based system via email. We've invested heavily in crime-fighting technology. We've invested hundreds of thousands of dollars in advanced electronic surveillance equipment so that we can do wiretap cases like the MS-13 case, where we're literally we're up on phones, over 200 phones at a time. We're running 5 wiretap investigations in the office simultaneously. That just did not happen in the past. And so we're going to continue to invest in those technologies so that we can keep Suffolk safe. We're going to continue to do the big cases on all the different fronts. We're leading the state on bringing OMT charges, top-to-top felony count for drug trafficking. We are leading the state in charging drug dealers who are causing overdoses with homicide charges, manslaughter in the 2nd degree. We are leading the state on all these different public safety issues, and we're going to continue to do that. And now, as DASNY's president, we're also going to play a very important role in improving the laws, whether they're the bail laws, the discovery laws, whether they're our vehicular laws. We have so much work to do in the second term. We're going to continue to move the office forward, make it strong. We're going to continue to decrease crime like we've been doing the last several years. Since I've been police commissioner and now DA, overall crime, index crimes, have been reduced by 20%, and violent crime has been reduced by 26 or 27%. So we're going to continue to do that, and it can't get done without the team that we have in the DA's office. It can't get done without the partnerships we have with law enforcement, and it can't get done without the partnerships we have in the community. So we're going to continue to invest in those partnerships, and we're going to remain fiercely independent. That's what we are, and that's what we're going to remain. Political party bosses and no other influence will be able to control the DA's office or even influence the DA's office, and that is critically important to a district attorney's office. It's critically important to our democracy.
Thank you. Mr. Tierney, we now welcome you to close.
I think in order to be an effective effective district attorney, you have to lead, you have to inspire, and you have to be independent. Nobody in this room thinks the district attorney would be here without the county executive. When I become district attorney, I will be that independent force. I will work with the county executive, I will work with the police, but I will be independent from them. I will not work for them. I will not excuse, and I will not excuse bad behavior. You need to be independent, separate and apart, 3 separate entities: district attorney, county executive, and police department. Right now, there is one entity, and it's controlled by one person. That will end under my watch. The district attorney's office will be separate, independent, and will follow justice. I will lead the office. We will be bold. We will return to criminal prosecution. It's tough out there with criminal justice, with the pandemic, but you must lead. You cannot leave dangerous drug dealers on the street. Individuals who possess fentanyl and cocaine, you cannot leave them on the street indefinitely. You need to have experience. You need to push your assistants to indict cases where appropriate. When you have 100 violent felons who are walking around with unregistered guns looking to do violence in your communities, you need to prosecute those individuals. A precursor to prosecution is indictment. You cannot prosecute somebody without their consent, without indicting them. We will return to the business of the people because we will prosecute dangerous people. We will do it quickly, we'll do it effectively, and I will use my experience, and I will make sure that we give our assistants all the resources they need to quickly and decisively prosecute those individuals who would harm the individuals in our communities.
Thank you. On behalf of the Suffolk County Criminal Bar Association, I would like to first thank both District Attorney Tim Sini and Mr. Ray Tierney in participating in this time-honored event. Hosting this candidate debate is deeply rooted in the history of our association, and I thank you all for attending. Our next CLE presentation will be a DWI training with Steve Epstein and Anthony Palacios. That will be Thursday,